Welcome. Today we're delving into the very foundations of our judicial system, the Supreme Court and the High Courts of India. We'll explore their historic origins, the formidable powers they wield as courts of record, and their diverse jurisdictions. Let's begin this journey through our constitutional corridors of justice. The Supreme Court of India came into being on 28 January 1950, just days after the Constitution was adopted and India became a republic. Enshrined under Article 124 of the Constitution, this apex court replaced earlier colonial structures to become the final arbiter of justice in our nation. Long before our modern system was fully laid out, the first three high courts emerged under the Indian High Courts Act of 1861. They were the Calcutta High Court, the Bombay High Court, and the Madras High Court. The Calcutta High Court, established in 1862, is often recognized as the oldest and serves as a symbol of judicial legacy in India. Both the Supreme Court and the High Courts function as courts of record. This designation means that every judgment, ruling, and proceeding is permanently documented. These records hold undeniable evidentiary value in any subordinate court and create binding legal precedents. In addition, high courts have the power to punish for contempt, imposing imprisonment, fines, or both, to maintain the dignity and authority of the judiciary. While the high courts can review and correct their own judgments, even though no specific review power is explicitly provided by the Constitution, the Supreme Court has been expressly granted the power of review. This power ensures that errors in judgments are addressed and that justice is rendered uniformly across the country. In our judicial lexicon, contempt of court isn't directly defined in the Constitution but is clearly outlined in the Contempt of Court Act, 1971. Under this law, contempt can be either civil, say for disobeying court orders, or criminal, which includes actions that obstruct or demean the court's authority. Judicial appointments are a critical element of our legal system. A judge of a high court is appointed by the President of India in consultation with the Chief Justice of India and the respective state's governor. After their appointment, the governor administers their oath of office. Additionally, a high court judge may even resign by writing to the President, although removal is also possible by presidential order should the need arise. Now let's break down the Supreme Court's three primary jurisdictions. Original jurisdiction involves disputes between the Government of India and one or more states, or between states themselves, as well as matters regarding the enforcement of fundamental rights. Appellate jurisdiction is where the Supreme Court serves as the final appellate body, hearing appeals on both civil and criminal matters from the high courts. Under advisory jurisdiction, the Supreme Court provides its opinion to the President on questions of law or matters of national importance. Certain constitutional provisions further define our judicial system. Article 122 directs that courts should not interfere with the proceedings of Parliament. Article 124 is the cornerstone for the establishment of the Supreme Court. Meanwhile, Article 241 empowers Parliament to extend or limit the jurisdiction of a high court over union territories, ensuring flexibility in our judicial framework. Across the country, high courts serve the states and union territories with powers tailored to their territorial jurisdictions. For instance, the Calcutta High Court covers West Bengal and the Andaman and Nicobar Islands, while the Bombay High Court oversees Maharashtra, parts of Goa, and others. Although the Constitution doesn't specify the number of judges in a high court, the President determines its strength. Notably, a permanent judge of a high court enjoys tenure until the age of 62. To maintain a quorum, Article 127 allows the Chief Justice, with the President's consent, to appoint a high court judge as an ad hoc judge in the Supreme Court when needed. Additionally, Article 126 covers the appointment of an acting Chief Justice. If the Chief Justice's office becomes vacant, or if the Chief Justice is temporarily unable to perform his duties, the President appoints one of the other Supreme Court judges to act in that role. In the Supreme Court, judges retire at the age of 65, which differs from Britain's retirement age of 75. Moreover, our Constitution sets a maximum of 34 judges for the Supreme Court, ensuring a streamlined and effective bench that upholds the rule of law while maintaining judicial efficiency. From its historic inauguration in 1950 to the dynamic roles it plays today, the Supreme Court remains the apex guardian of our rights and liberties. Coupled with the High Courts, our trusted courts of record, they not only record the annals of judicial decisions but also enforce, review and correct them. Together they form the backbone of India's justice system, ensuring that every citizen's rights are protected under the law. Thank you for joining us on this comprehensive exploration of India's Supreme and High Courts. Like, subscribe and share to help others understand the incredible framework that upholds our democracy.